Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Yep, absolutely. How about having poor record keeping bad records? How can that have an impact on your case?
I always think of proper planning prevents poor performance.
5 Ps. That's right. 5 Ps.
And if you don't really have proper records, again, it's hard to represent the client because they may only have part of the story. In family law, everything goes back to being a story. And when I would teach attorneys on how to litigate, I always start with, what is your theme? What is going to be the story of your case? It doesn't have to be anything, theatrical or Hollywood or anything like that, but there's always going to be a theme. And what is that? And let's stick to that. And if we don't have the records to support that, that really makes it hard. And then if you have incomplete records, it makes it hard, especially you mentioned subpoenaing records or discovery phase. If we're only producing half the documents, then the other side is going to file potential other motions to get those, whether it's filing sanctions against us or motion to compel, or they may just through their own due diligence as they're reviewing the records saying, well, wait a second, I see a transaction here, but I can't connect it over here. Where are these documents? And then the client may just be unorganized. And it's hard to remain completely organized, especially when you process like this. But again, going back to that perception as reality, the court may think, wait a second, they're not fully telling the truth, and now I'm going to question their veracity. And a lot of decisions when it comes to family law is based upon credibility. And if the court or if there's a guardian ad litem, which is someone appointed represent the best interests of the children or child, if they don't find that you possess credibility, then the court may put everything into question as far as the credibility and the veracity, and you may have an order that's not as so advantageous for you or what your ultimate goal is. So you really want to be as organized as possible. But going back to what we talked about earlier, as far as the right attorney, that attorney will help guide you. And he or she may have a paralegal, and having a strong paralegal is good because they'll go through the records and they'll be able to identify any potential missing links that there are or issues. And then we can start flushing them out and addressing. So we know in advance, what do we need to look out for? Or are there other documents that may be missing that you can supply? Or maybe it's a situation where you just don't have them because they've been destroyed or they just haven't been preserved. So we just want to make sure that we're allowing the other side a fair opportunity for that disclosure.
Right. And especially if you have some sort of separate money, if you received like an inheritance or you're trying to show that something was premarital or only part marital or something like that, if you don't have the records to support it, the judge is going to say, sorry, we're going to presume everything to be marital and it's your job to prove otherwise. So if you don't have good records of that, you're going to be missing out on whatever that separate share is that you were entitled to. Another thing I think of is we always advise our clients to like keep a journal, right? Just write stuff down as it happens. Because when a year from now, when you're on the witness stand and you say, when did that happen? And you're struggling to remember, well, I think it was summer because it was warm. And, it just, again, it calls in that veracity compared to if you have some notes you can reference and you can say, yes, it was on July 31st. This is what happened and this is why. And everything else just helps you keep on top of those important things that you're going to need to communicate to the judge, but it's not going to be tomorrow. It's going to be a long ways from now. So you have to have some sort of record to rely on. Now, how about sharing too much on social media or sharing too much with mutual friends? How can that impact your case?
That's just a hard no. And especially in today's day and age, everybody just wants to share. I mean, I find it funny because there's always this is my private information. I don't want anybody to know it, but we're all just sharing everything, what we do.
Right.
And again, it just has such detrimental effects, and you may not even want that to happen. That might not be your intention. But I've been involved in cases to where the other side was posting pictures. They were out, but yet they were saying they were home with the kid, or that they weren't having an affair, but they're always out with this particular person. Or they post a picture, but yet in the background, there's all this alcohol, but they're hanging out with the child. And it's just, it can be used as a weapon against you. And I always advise clients, unless you have to, if you're a social media influencer or as part of your job that you have to post on social media, really either limit or eliminate it until the proceedings are over. But I also want to know what is out there, because you can't just go back and delete social media posts that are out there, whether on Twitter, Facebook, Instagram, or I know I'm missing a ton of other things that are out there. I'm just not hip, but it's really going to be dependent upon, you have to preserve that, because otherwise then that's spoliation of evidence. And it goes back to what we were talking about earlier, as far as your credibility. And so just own up to it and talking to your attorney. Oh yeah, I posted some pretty negative information about my significant other. But again, you're going through a bad time. A lot of people use social media to vent, and it's just, don't do it. Talk to somebody as opposed to putting things in writing. The best piece of advice I believe that I give clients is anything that you put in a text on social media and an email, just pretend that judge is on that as well, because 9 out of 10, what you're communicating is discoverable. And I say 9 out of 10 because it could be an email to your attorney and there's potential privilege attached to that. But 9 out of 10, that's discoverable, and it could just have detrimental effects on your case.
Yeah. There's a joke from, I think it's John Mulaney, the comedian, and he was talking about a situation where years and years later, right, there had been a dispute with his college friends and a landlord or something, right? Years and years and years later, apparently a lawsuit's still going on, and he gets pulled back into it because at some point he had emailed his friend and said, "Oh, you're still dealing with that. Do you want me to kill that guy for you?" And just completely, joking and just nonsensically talking about it. But he was like, I got pulled in for a subpoena or something, like had to go to court about it. And everything, it's true. Everything that you put in writing, you have to think about, what if this was read in court one day? How would it reflect on me? How is it going to look to a judge? And then, it's the same thing with sharing too much information with your friends. If you start sharing everything, oh, well, this is what's going on, this is what my attorney's going to do, and this is what we're thinking about filing. Well, you have privilege with your attorney, but you don't have privilege with that friend. And if they turn around and go tell the other side exactly what's going on, they can do that. So you have to guard that. If you want to use that confidentiality, you want to use that privilege, make sure that you keep it right in your favor, in your benefit. Now this one I think is kind of funny just because of the phrasing, but what would you say about somebody who's neglecting their attorney? Oh, so neglected.
Don't do it. Again, it's communication. Your attorney's there to represent you. And if you're neglecting your attorney and you're not returning emails or phone calls, because they're wanting documents and it could be time sensitive. And if us as practitioners, if we can't get a hold of the client, we may think that the client has abandoned the situation, and therefore we either have to dismiss the case or file a motion to withdrawal as their counsel, which could have, again, detrimental effects in the sense that now you don't have an attorney and there's these deadlines that are looming. But it's hard for us as practitioners to represent someone if they're not responding. And unfortunately, it does happen. I get it. Life happens, and sometimes it's hard not to respond. But at the same time, you reach out to the attorney. You're the one going through probably one of the worst times in your life. So you have to make it a priority. And if it's not, you're really just setting yourself up for failure, in the sense that you're not allowing your attorney to really do what they need to do to protect you. And that's, at the end of the day, that's what, to me, is what it means, is you want protection for your children. You want protection for your finances. You want protection for your assets. You want protection, make sure that you're not saddled with all the debt that's been incurred throughout the marriage. And then, as you mentioned earlier, you want protection if you have separate property, if there's trust, if there's money that's been just given to you, you want to make sure that you're preserving that for your interest and your interest only.
Right. I think the phrasing is hilarious. Don't neglect your attorney. But we've had clients that we've had to fire, basically, because they won't keep up with us. And we tell them, we need this information. We need to move forward. We need to do this. We need to do that. And it's not like we're expecting a response in 10 minutes, but you can't just disappear off the face of the earth for months and have no response and no involvement in your case. We cannot do the case without the client. We have to have the client participate in the case. So definitely a major mistake. You're setting yourself up to end up paying the attorney's fees for the other side, most likely. and you're setting yourself up to just lose whatever it is that you're trying to fight for, because your attorney can't possibly be prepared. Now, how about this one? Not preparing to testify before going to trial.
Ooh, that's a tough one, because as a lawyer, I would want to know, why do you not want to testify? Again, it goes back to being open and honest. If it doesn't make sense to put you on the stand, then we won't. But I also caution clients, because I always hear, oh, I'll just plead the fifth. Okay, you can do that, but remember, we're not in criminal, we're in civil. And
Right.
so pleading the fifth can be used against you, in the sense that court could take that as a negative inference. Yeah, you don't have to disclose it. Fine, plead that fifth. But the court may say, all right, yeah, but I think that there may be some questions, so I'm going to rule in favor of the other side on whatever issue it would be. And so if you don't want to testify, I really want to know why. And you may think as the client, oh, I'm just embarrassed, or they're just going to really hammer me because of what I've done or what I'm going to admit to. They may, but it may not be as bad. And in my experience, I always like to stay ahead. If I know that there's an issue, I'm open about it. And say, yep, my client did this. Let's move on. Or here, yeah, my client had a drinking problem. They're in therapy right now, or counseling, because they want to get help and they want to make sure they're better for their kids. So let's stay ahead of it. Yeah, let's turn that negative into a positive. And it can happen, but it's owning it and then moving forward.
Right. I mean, you can't fake it, right? You can't get around it. Once you're on the stand and you say the wrong thing, or you get angry, or something else happens, there's no taking it back. And so you can't prepare too much for that situation. And I love to have clients come in and do a whole lot of preparation for both the direct exam, get prepared for cross exam. If I were on the other side, this is what I would attack. These are the questions I would ask. And I would box you in to having to say yes or no to certain questions where you want to give more explanation. The judge doesn't go for that, right? The judge is going to sit there and say, no, he asked you a yes or no question. The answer is yes or no. And those are the types of things that you absolutely have to be prepared for. And I've heard, we've not represented a lot of attorneys, but I've heard that attorneys actually make the very worst witnesses. And so they need more preparation than anybody else, because otherwise they just sort of spill everything out, and they want to give you the explanation and the context and everything else. And so if you have an attorney as your client, you really have to prepare them and get them focused in on yes or no answers, and keeping it short and sweet and all that kind of good stuff.
Yeah, answer the question that was posed to you.
Answer the exact question that was asked of you. What day is it, right?
Right. That's what I was going to say.
That's it.
That's the one I use all the time for clients.
No more, no less. Absolutely. Well, this has been fun. So for those of you joining us, thank you so much. Again, this has been the I Now Pronounce You Divorced podcast, and we've been talking about the 10 dumbest mistakes that we've seen in divorce cases. If you liked this content, please like and subscribe. We also have an ebook available where we talk a little bit in more detail about how to best prepare for your divorce case. And if you're looking for more information, please reach out at Malone Hatley PC. We are your partner in divorce.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.